The Alberta Energy Regulator has come under scrutiny lately for a number of incidents, and Energy Media has been talking to various experts about how the AER operates. Today, I'm going to be talking to Katie Morrison, who's the Executive Director, the Canadian Parks and Wilderness Society, Southern Alberta, about mining applications, coal mining applications. So welcome to the interview, Katie.
Thanks for having me.
Now, I've talked to one other ecologist, Lauren Fitch, did an interview about the mining side of the AER's activities, and he was talking about how these stonewalled, couldn't get information. But you had a bit of a different but similar kind of experience around the Elan mine application. Can you tell us that story, please?
Yeah, and I mean, we also have had similar experience of having trouble getting information. And in this case, it wasn't just that we couldn't get the information right away, but we'd found that the AER was really moving quickly on approving applications that we had concerns about. So in this one, or actually ended up being two particular cases, Elan Mining Company had applied for an exemption to a rule that protects goat and sheep habitat during really sensitive times when they're kidding and lambing in the spring and in sensitive times when going into the winter and the fall. And so Elan had applied for an exemption to drill in these areas during that time when no activity is supposed to be happening to protect sensitive sheep and goats. So we went through the process. I mean, finding these applications in itself is a massive endeavor. They don't notify you, so we just have to go back, on a weekly basis and check what's happening on the ground in areas that we're interested in. So we had found an application for this exemption to drill in the sensitive sheep and goat habitat. We went through the process of requesting the entire application, because often online it doesn't show you what the application is actually for. You have to pay at times or request the information. So we got the information, wrote a statement of concern about this exemption to drill, and in the response to our statement of concern, it said that that our concern wouldn't be registered because the application had already been approved. When we looked into those dates, the application had been approved 1 working day after the application had been submitted. There wasn't really a good reason for that approval, other than Elan had said, if we don't apply for this exemption in the spring, we're going to have to apply for it in the fall. So we were quite concerned about this. We wrote back to both Elan and the AER saying that was unacceptable, did some communications on it. Then comes the fall, and we're doing the same process of looking at the applications, and found that Elan had once again applied for the same exemption in the fall, which they said they wouldn't do if they got it in the spring. And that exemption was approved the same day, and therefore our statement of concern was not registered because it had already been approved. There was no opportunity for our or anybody else's input into that process.
This seems to be a recurring theme here, and Energy Media viewers who've listened to the podcast and watched the video interviews that I've done with experts around the AER, and the argument has been made many times that the AER is a captured regulator. That is, instead of balancing public interest and industry interests, it is skewed towards industry interest. And in this case, greatly skewed. And in fact, a number of experts, including people like Dr. Kevin Timoney and Professor Jason McLean from University of New Brunswick, have argued it was set up that way from the very beginning. It's always been captured. Decades and decades ago, Alberta's regulator has been captured. And it seems like this is the way it's done. It's very much it's one of the techniques where the procedures are set out. When the Alberta government rescinded the coal policy in May of 2020, it said, quote, all proposed coal projects will be submitted to the Alberta Energy Regulator and rigorously reviewed based on their merit. So the government says, this is our policy, this is the way it's going to work. The AER agrees, and then they don't do it. And that is just a recurring theme. If I've heard it once, I've heard it 25 times. And it seems like this is the case again here. Have you got any other examples? Does this happen to your organization all the time?
Well, I think that's a really clear example because it was, like same day approvals for something that we were really concerned about. When I was reviewing the statements of concern that we put in through the rescission of the coal policy, so we put in about 10 statements of concern in 2020, 2021 around exploration or water withdrawals associated with coal mine exploration. And some of those, as the example that I just gave, had already been approved, and so our statements weren't registered. In almost all other cases, our statement was registered, but when they looked into our statement, because we aren't directly affected, we don't own land on the development or adjacent to the development, we weren't considered to have standing, and therefore, our concerns weren't really taken seriously. And that's really frustrating when it comes to public land where a lot of this activity is happening, that there isn't a public consultation process. There isn't a way for us as organizations that represent constituents or individuals to be part of that process. And that's a real concern when we're looking at how these are approved and whether they're in the public interest or not.
Now, let me understand this. The AER said the application is to develop on public land, so owned by the government, whether it's, I presume in this case, provincial land. And the government, and you put in an application, a statement of concern, you raise issues, and the AER says only landowners who have a direct stake in this can submit a statement of concern that we'll consider. But because it's publicly owned land, there is none. The owner of the land is in fact the government of Alberta. Have I got that right?
Yeah, that's correct. And I mean, you would say that the owner of the land is government of Alberta on behalf of Albertans. And yet Albertans don't actually have an avenue to participate in that process.
Well, I read Catch-22 a long time ago in college, but boy, this is a classic example of a Catch-22. And what is your general impression of how the Alberta Energy Regulator approaches these kinds of developments, Katie? Would you agree or disagree that the regulator is captured and primarily serves industry interests rather than the public interest?
Yeah, I mean, I think my experience has mostly been through the coal mining applications and exploration applications, but certainly the tone of both the applications and often the correspondence to the applicant that we could get or to us was there was an expectation that projects are approved regardless, and that there isn't really any other outcome, and that I think is really inappropriate for a regulator that is supposed to be looking at the public interest in mind, to be protecting environment, making sure that those decisions are made based on that cost risk benefit to environment and public interest. But from my experience in the coal mine applications, that it really is, it's an expectation. It's a rubber stamp type of approval process.
And if I understand correctly from the blog post I read, the rigorous review that the government promised in the land case was one question. Is that right? Yeah,
and we requested some additional information around how this was approved. The only question that the government or the AER, had asked the company on this application to drill in sensitive wildlife habitat was why they needed the approval now. The company said, well, we need it now, or we're going to have to do it in the fall. And so, and that was, in that vein of, they're going to get it. We either to get it now or we get it later. It wasn't, about the merits of should they be in this area at all, and particularly during this time that the government has laid out is a time that is to be avoided for industrial activity to protect sheep and goats.
So the application, the question sort of begged the question, it's going to be this time or it's going to be that time, and then it turned out to be both times.
Yeah, that's exactly it.
Well, Katie, thank you very much for your insights in this. Really appreciate it.
Yeah, thanks for having me on.